Chapter 4. Subrogation among joint debtors. 169. Right of joint debtors to subrogations against each other. The right of subrogation among parties severally bound as principals has been denied. But the usual rule is that one of several joint debtors will, as against his co-debtors, ordinarily be subrogated to the securities and means of payment of the common creditor whom he has satisfied, so as to enable him to recover from his co-debtors, by means thereof, their proportional shares of the indebtedness which he has discharged. And this, as in other cases of subrogation, arises rather from natural justice than from contract. Each joint debtor is regarded as the principal debtor for that part of the debt which he ought to pay, and as a surety for his co-debtors as to that part of the debt which ought to be discharged by them. Thus, if three persons mortgage their joint property to indemnify the drawer of certain bills of exchange drawn for their accommodation, each of the mortgagors agreeing to take up a third part of the bills on their return, and then two of them neglect to take up their 2/3, so that the other mortgagor is compelled to pay the whole of the bills, in consequence of which he requests the drawer not to release the mortgage, but to hold it for his benefit, an equitable lien is thereby created upon the mortgaged property to the amount of 2/3 of the bills in favor of that mortgagor who took up the bills. Where one of several proprietors of land pays the whole cost of a pavement laid on the requirement of the municipal authorities, for which the property was bound and the proprietors were individually liable, he will be subrogated to the rights of the paver, to enable him to recover their proportions from the other proprietors. Where two joint purchasers of real estate gave to their vendor a mortgage thereof to secure the payment of the purchase money, and after the death of one of them, the survivor paid the purchase money, the latter was subrogated to the lien of the mortgage, and allowed to hold the mortgaged property for the excess of the joint debt paid by him above his proportion thereof against the widow and heirs of the deceased purchaser. But the creditor may of course hold all the debtor, and all the securities that they have given, until he shall be fully satisfied. 170. Where one joint debtor has assumed the ultimate liability. If, as between joint debtors, it has become the duty of one of them to pay the entire debt, the others, if they shall be compelled to pay it, will be subrogated to the securities and means of payment held by the creditor against the former, just as if they had been sureties of the former eo nomine. Thus, if two of the three principal obligors in a bond put into the hands of the third the means to pay it, but he fails to do so, and a judgment recovered upon the bond against the three is paid by one of the two, the latter will be subrogated to the lien of the judgment upon the lands of the third in the hands of his grantees, to whom he has conveyed them since the judgment. The same principle was applied in a case in which it appeared that the plaintiff and M, being partners, agreed that M should pay the defendant for property which they had bought of him, and M accordingly sent high note to the defendant, who declined to receive it as payment, and demanded and received the price of the property from the plaintiff. The plaintiff and the defendant then agreed that the defendant should still hold M's note, and conceal the plaintiff's payment, and should turn over to the plaintiff whatever M might pay on the note. M, having afterwards made a payment on the note to the defendant in ignorance of the plaintiff's payment, it was held that the plaintiff had by subrogation a right to all the securities held by the defendant, and that M, a note being such a security, the payment made thereon belonged to the plaintiff. So if one of two joint debtors has given to their surety for the debt collateral security to protect him against his suretyship, and has then agreed with his co-debtor for a valuable consideration, himself to pay the whole debt, the other joint debtor, if he is afterwards compelled by the creditor to pay the debt, will be subrogated to the benefit of that security in the hands of the surety, whom B has discharged by his payment, in preference to the claims of the judgment creditor, A, of the debtor who should have paid the debt. The same rules will be applied if the joint debtors are a husband and wife who have been divorced. But the debtors cannot by any arrangement among themselves lessen the rights of the creditor against all or any of them. He may insist upon being paid in full, leaving them to adjust their own equities. And even after full satisfaction of the creditor, as subrogation is an equity to be enforced only where it will benefit a meritorious claim without doing injustice to others, it will be denied if the person claiming it has agreed for value to waive his right, or if he is indebted in a larger amount to the party against whom he seeks it. 171. In Cues of partnership. A partner who, after the dissolution of the partnership, pays a firm debt out of his private property may in equity enforce contribution therefor from his copartners, by virtue of the partnership agreement to contribute to losses rather than by way of subrogation. But he cannot claim any lien upon the separate estate of his partner in bankruptcy for the balance due to himself upon settlement of the partnership accounts, by subrogation to the rights of a firm creditor who has been paid out of the firm property. For partnership creditors have themselves no lien upon the firm property and can secure its application to their claims only through the rights of the partners. The creditors of a partner who is entitled to be subrogated as against the firm will succeed to high rights, and the legatee of a partner subject to the payment of high debts will occupy the same position. If individual property of one of the partners of a bankrupt firm has been pledged for a firm deb, the creditor may, and if requested by separate creditors of that partner, must prove high hold debt against the firm assets for the relief of that partner's separate estate, thus in effect subrogating that separate estate to the creditor's right against the firm. The subrogation of one partner who has paid a firm debt to the position of the creditor as against his copartners cannot ordinarily be enforced without a settlement of the partnership accounts. Nor can the bail of one partner who have, as such bail, been compelled to pay a judgment recovered against that partner for a firm debt recover at law from the other partners any part of the sum thus paid by them. Nor after suit brought upon a partnership debt and its satisfaction by one of the partners sued, can equity preserve or extend the validity of the original security under the guise of an assignment, so as to charge the bail of another partner for the farmer's reimbursement. But a partner who has gone out of the firm and taken for a valuable consideration the agreement of the remaining members of the firm to indemnify him from the partnership debts, will in equity be regarded as the surety of the other partners, and will, if he is compelled to pay a firm debt, be subrogated to the rights and remedies of the creditor, therefore against the remaining members of the firm. If one partner buys the interest of the other in the firm property, and assumes the firm debts, he will in equity be regarded as the principal debtor, and the other as merely his surety, and a firm creditor who has notice of the facts has been said to be bound at his peril to treat the former partners respectively as principal and surety, though any such limitation of the creditor's original rights can scarcely be maintained on principle. 171a. Substitution of a partnership creditor to agreement or security taken by a retiring partner against firm debts. The Court of Appeal of the State of New York and the Supreme Courts of Pennsylvania and Arkansas have refused to allow the creditor of a partnership to maintain an action upon a bond given to a retiring partner by the remaining members of the firm to secure him against his liability for the partnership debts, upon the manifest ground that the bond was given, not at all for the benefit of the firm creditors, but solely for the protection of the retiring partner. But if the bond is conditioned both for the relief of the retiring partner and for the payment of the outstanding firm debts, it has been considered to be more than a mere contract of indemnity, and both the obligee of the bond and the firm creditors themselves have been allowed to proceed upon it to enforce payment of the firm deb. The remaining partners, by their agreement to appropriate the firm property to the payment of the firm debts, have been held to become trustees for the creditors, and will be held by a court of equity to the proper discharge of the trust. The same principle will be applied to the deposit by the retiring partner of a sum of money with the new firm which, by agreement between him and the members of the new firm, is to be applied to his share of the liabilities of the old firm. It becomes a trust fund for the creditors of the old firm, and their rights will not be affected by any subsequent equities that may arise in favor of the members of the new firm. But a promise by the members of the new firm to the retiring partner, upon their taking merely the assets of the old firm to pay its debts, though it has been held to give the old creditors a direct right of action against these new members or others who have made it, under the liberal doctrine that one for whose benefit a promise is made may enforce it, though not a party to it or privy to the consideration, yet gives the retiring partner no lien upon these assets for the enforcement of the promise, and gives the firm creditors no lien upon the assets which can be enforced against third persons to whose hands these assets come without notice of any trust, and no special rights, it is sometimes held, against the remaining partners personally or against the assets in the hands of the latter, even though the firm and all the partners were insolvent when the promise was made. The right of partnership creditors to hold the partnership property doubtless arises by way of subrogation to the right of the partners to have the firm property applied to the payment of the firm debts. But these rights are now a part of the law of partnership rather than of subrogation. 172. Where securities belonging to different owners are held for the same debt. Where securities belonging to several different persons are held together to secure the payment of a single debt, they should be applied pari passu to the satisfaction of the creditor, so that each of the several owners of the securities may contribute his just proportion of the common burden. And if such creditor satisfies the demand out of the securities of only one of the owners, leaving the other securities undisturbed, equity will so dispose of these others as to throw the burden of the debt upon all in reasonable proportions. The one whose property has paid the whole debt will, to the extent of his actual payment, be subrogated to the rights of the creditor against the others, and may hold their securities to enforce the payment by them of such sums as they ought in equity to contribute. If the security is a mortgage, and the whole debt is paid to save the estate of the party paying it, by one of two tenants in common who have, since the giving of the mortgage, acquired the equity of redemption, the assignment of the mortgage to this covenant will not extinguish its claim in favor of the other, who has paid nothing. That share of the mortgage debt, which it belonged to such an assignee to pay, is extinguished, his title to his portion of the mortgage property is perfected, and he is subrogated to the rights of the mortgagee as to the other share, and may call upon his covenant to pay him the proportion of that share, or be foreclosed of the right to redeem. If the creditor himself purchases the share or the property of one of the debtors subject to the burden, a corresponding share of the debt is extinguished. As between the purchasers in common of an estate bound by a joint lien, each share is obliged to contribute only its proportion of the common burden, and beyond this amount is to be regarded as the surety of the others. And if the owner of one share is called upon to pay more than its due proportion of the debt, such owner or his creditors will be entitled to stand in the place of the satisfied creditor to the extent of the excess which ought to have been paid out of the other shares. One tenant in common, upon redeeming the estate from a tax sale, though he will not acquire an absolute title, yet, if his payment were necessary for the protection of his own estate, may hold the estate under his tax title against his cotenants until they pay or tender to him their proportion of the taxes. As his redemption will be deemed to have been made for their benefit, if they so desire on their payment of their proportionate shares of the indebtedness, so it will be for his own benefit until they shall make such payment. 173. Where land of two or more owners is subject to one mortgage. Where one of the owner of land subject to a mortgage pays off the mortgage debt by installments, and upon making the but payment takes an assignment of the mortgage, its lien is not thereby extinguished in favor of the other owners. Either one of such owners, where they hold distinct parcels of the encumbered estate, or are tenants in common of the whole, is at liberty to redeem for the protection of his estate. And upon so redeeming, he becomes subrogated to the rights of the mortgagee, and may hold the land as if the mortgage subsisted, until the other owners reimburse him their proportions of the encumbrance. And in the absence of any agreement their proportions will be according to the proportionate value of their respective interests. The grantee of such an owner will have the same right of subrogation as was possessed by his grantor. Where two chasers of land gave their joint notes for the purchase money thereof, secured by a mortgage of the premises, and after a partition of the premises one of them refused to pay his proportion of the last note, so that the other was compelled to redeem the whole mortgage, the latter was allowed to hold the land of the defaulter for the amount which he had thus been compelled to pay above his own share of the note, and to have the same interest as had been agreed to be paid upon the original debt. Upon the same principle, the assignee of a mortgage which covered 3 estates, having purchased 2 of these estates, can recover from the third estate only its rateable proportion of the mortgage debt. 174. This principle applied against one claiming under a joint purchaser. One person and 4 others purchased a lot of Jan and gave for the purchase money their joint notes secured by a mortgage upon the lot. They then divided the lot among themselves into 4 equal parts, one of which was allotted to Pearson, and agreed to give each other quitclaim deeds of their respective parts. Pearson took possession of his part, built a house upon it, and when sold it to one Williams, who paid him therefore in full the title still remaining in all the purchasers, they joined in conveying to him the parcel purchased by him of Pearson. Pearson paid nothing of the original purchase money, of which he should have paid 1/4. The remaining 3/4 were paid by the other purchasers. The mortgagee then filed a bill to foreclose his mortgage for the unpaid fourth part of the purchase money, and it was decreed that the part of the lot set off to Pearson and conveyed to Williams should be first sold, Judge Davidson saying, the several owners of the residue of the lot having each paid 1/4 of the purchase money, the remaining fourth was in equity the debt of Pearson. And as his debt, it was properly chargeable on the property set off to him. It was not pretended in this case that Williams had noticed that Pearson had not paid his share of the purchase money, but having notice of the mortgage, he was to be regarded as having purchased subject to the equities that arose under it. But under somewhat similar circumstance in Georgia, it was held that one purchaser who had been compelled to pay the whole of the purchase money was not to be subrogated for his reimbursement to the mortgage lien upon the share of the other purchaser in the hands of a grantee from the latter, although such grantee had constructive notice of the mortgage from the fact of its being recorded. 175. Applied to mortgagees whose estate was subject to a prior lien. Where 3 junior mortgagees of land, having no priority among themselves, had agreed with the mortgagor that if it should be necessary to redeem from the prior mortgage, each of these 3 junior mortgagees should pay 1/3 of the amount due thereon, and be indemnified therefor out of the property. And one of the 3 paid 1/3 of the amount due upon the prior mortgage, and then advanced the remaining amount and took an assignment of that mortgage, it was held that as to the remaining 2/3 he became subrogated to the rights of the prior mortgagee, and might require his co-mortgagees to redeem by paying to him those 2/3, or to forfeit all title to the mortgaged premises. 176. Not applied where lien upon one security extinguished. If 2 securities are held for the payment of a debt, and the lien upon one of them has been lost by lapse of time, the owner of the other security, upon paying the debt, will acquire no right of subrogation to that which has been thus discharged. A testator devised a tract of land to his 2 sons, Benjamin and Thomas. The purchase money due from the testator for this land being unpaid, the testator's vendor brought his bill against the executors and obtained a decree charging the land with its payment. By a subsequent decree, the land was ordered to be sold therefore. While these decrees remained unexecuted, Benjamin sold his portion of the land, and the purchaser thereof took and held possession until, by the lapse of time, he acquired a title which was valid against these decrees. Then the decrees were revived, and by order of the court, the remaining portion of the land, being the share of Thomas, was sold for the payment of the testator's indebtedness for the price of the whole tract. On a bill brought by Thomas against Benjamin for contribution, it was held that, as the vendor's lien upon the whole tract had been lost and ended by the statute of limitations, so that the complainant could not have been subrogated to that lien, his payment of the debt conferred no benefit upon Benjamin, and consequently that Benjamin was not bound to contribute for his relief. Nor can one joint debtor be subrogated to the benefit of a security which has been otherwise lost as against the other. Where 2 purchasers of land gave back a mortgage for the price thereof, which, however, was not recorded, and the interest of one of them was subsequently conveyed to a bona fide purchaser for value who had no notice of the unrecorded mortgage, it was held that the mortgagee might yet enforce his mortgage for the whole amount remaining due thereon against the interest of the other debtor, who must then look to his coadjutor personally for the payment of the latter's share. 177. Where the ultimate liability is upon one of several owners of securities held for the same debt. If the property of 2 owners is subject to a mortgage, and as between themselves it is the duty of one of them to discharge it, and the other pays the debt on an agreement that the mortgage shall inure to his benefit, or if he takes an assignment of the mortgage, he will be entitled to reimbursement through the lien of the mortgage. The relation between the debtors or the owners of the encumbered property in such a case is that of principal and surety. The primary and ultimate liability is upon him whose duty it is to pay the debt and upon his property. His payment of the debt will discharge it in favor of his coadjutor, and the grantee of his property encumbered with the debt, who has notice of the encumbrance and of the respective rights of the parties, will be in no better position than high grantor. he must pay the whole debt, even though his co-debtor should convey the other encumbered property to the common creditor. And in such a case, a court of equity may order the properties or interested which the creditor holds for the security of his debt to be sold in the succession or in the proportion in which they are, among themselves, liable for its payment. Thus, where the joint purchasers of land, having given back a mortgage for its price, made partition of it among themselves, and one of them paid his proportion of the mortgage debt, it was held that the court might properly order the share of the other purchaser to be first sold on a foreclosure of the mortgage. And although, where a bill to redeem from a mortgage is filed by several persons as owners in different proportions of the equity of redemption, the proceedings of the mortgagee to enforce his security will not be delayed until the complainants have settled the proportions in which they are respectively to contribute to the redemption. Yet, if they pay into court the full amount which is due to the mortgagee, the suit may be delayed for a reasonable time to enable them to proceed against another defendant, who is also interested in the equity of redemption, for the purpose of compelling him to contribute his proportion of the mortgage debt. 178. These principles applied to joint mortgage and to the grantees of a mortgagor. C. and S. purchased a lot of land and gave their joint note and mortgage for the price thereof. Afterwards conveyed his undivided half to S subject to the mortgage, which S assumed and agreed to pay, and gave to C a bond of indemnity against the same. S subsequently conveyed the lot to a grantee with full covenants of warranty and against encumbrances, and then became insolvent and left the state, having failed to pay the mortgage debt. The mortgagee having brought a suit against C on the note, instead of proceeding against the land, C thereupon tendered to the mortgagee the full amount due, and demanded an assignment of the note and mortgage to a third person for his benefit, so that B might enforce them against the land for his indemnity. But the mortgagee refused to make such an assignment. It was held, on a bill in equity then brought by C against the mortgagee and the grantee of S, that the arrangement between 0 and S, and the conveyance from the former to the latter constituted in equity the relation of principal and surety, not only between themselves personally, but also with reference to their interest in the mortgaged property, that the equitable rights of 0 and S were now the same as if S had originally owned the whole lot and had given the mortgage for his own debt, and C had been merely his surety. That accordingly the land was the primary fund for the payment of the debt, and the surety, if compelled by the mortgagee to pay the debt, would be entitled to be subrogated to the charge of the mortgage upon the land, and that C.'s rights were not affected by the fact that he had taken a bond of indemnity from S, for as S was insolvent, his sureties on that bond might well insist that the land should be first resorted to for the payment of the mortgage debt, instead of its being collected from C, and their liability to him upon the bond then becoming fixed. The owner of land mortgaged it and subsequently sold a part of it to a purchaser, who assumed the mortgage, but failed to pay it, and conveyed the land he had purchased to B, who had notice of the facts. In the meantime, the mortgagor had conveyed another portion of the mortgaged premises to C, who conveyed it with warranty to another purchaser, and the mortgage being still unpaid, this last purchaser, to relieve his estate, applied to its discharge a portion of the purchase money which he would otherwise have paid to C. B, being still indebted to his vendor for the price of his land in a sum greater than had been paid for the discharge of the mortgage, it was held that C, having in effect, through the payment made by his grantee, redeemed from the mortgage, was entitled for his reimbursement to be subrogated to its lien upon the land of B, which should have discharged it. So when the amount due upon a purchase of two separate lots has been apportioned between the two purchasers of each lot, and the purchaser of one lot has paid his share of the debt, the other lot should be sold first upon foreclosure of the mortgage for the balance due thereon, as against a subsequent purchaser of that lot, whose deed was made subject to all existing mortgages. 179. Extent of the right of subrogation. This right of subrogation is paramount to any other claim or lien upon the property against which it is sought to be exercised, if such other claim or lien was subject to the obligation which has been discharged by one debtor, or to the satisfaction of which his property has contributed more than its equitable share. But it cannot take place beyond the amount actually paid under a legal liability or under compulsion, by or from the property of the one who seeks to enforce it, nor beyond the proportional share of those who are, either personally or by a pledge or mortgage of their property, jointly liable with him. He cannot be subrogated upon the payment of anything less than his proportion of the debt, although the others have paid nothing. If one of several obligors in a bond, each one of whom is bound for himself alone, overpays the amount due from himself, this overpayment, being made only upon his own liability, gives him no right of subrogation against the others, and does not inure to the benefit of either of the others. Nor can there be any subrogation if nothing more appears than that the joint debt has been paid, without any indication by whom or upon whose credit this was done. 180. Whether original obligation discharged as to all the debtors upon payment by one. It was at one time held in Pennsylvania that, although a surety who has paid the bond debt of his principal will be subrogated to all the creditor's rights and remedies against the principal, this rule will not be applied to a payment made by a joint debtor in a bond who is not a surety, but his claim against his co-obligors will be treated as merely a simple contract claim for contribution. But this distinction has not since been followed in that state. The rule in England is now the same in this respect as to both sureties and joint debtors. And in this country, the same principles are generally applied between joint debtors or other persons who are, either personally or by a charge upon their property, liable for the same debt, as between principal and surety, though the claim of a mere joint debtor to subrogation has often been less favored than that of a surety, on the assumed ground that the payment of a debt by one of several joint debtors inures to the benefit of all of them. If the principal obligation is held to be extinguished upon its payment by one of the debtors, it cannot be kept alive by being assigned to a stranger who has paid it with money furnished to him for that purpose by one of the debtors. But if the assignment was made to the stranger by contemporaneous agreement to secure him for advancing money to take up the indebtedness, though at the request of one who is liable for the debt, such an assignment will not extinguish the original obligation.